Good evening, everyone. Chip Cooper for FTC Guardian and also my partner, Alan Cutts. We've got, I think, an excellent presentation for you tonight all about membership sites and a specific new legal development that occurred about 2 months ago. When I finish with this presentation, Alan has got some important information to share with you about the affiliate program. So without any further introduction, I think I need to go ahead and get started into the slides. Okay, you see the title slide here. Let me make sure that it's all working here. Yeah, there we go. The title slide, learn the harsh lesson.
Wait. It's not showing yet.
Okay, well, I thought it was. Let me click. Can you see it now?
Nope.
Well, let me switch back to, something has happened here because I cannot go back to see myself. There I am. Let me try one more time to switch this thing over to screen share and see.
Okay, you're good. You're good.
All right. Sometimes, every time, we've done a lot of these Hangouts, but every now and then the technology trips me up a little bit. All right. Learn the harsh lessons of the One Technologies case for membership websites. And of course, we start with a little housekeeping. The Hangout is provided for informational purposes only. It doesn't constitute legal advice, and it shouldn't be construed as legal advice, and it doesn't create an attorney-client relationship. So we're going to be talking, generally speaking, about continuity billing plans, but we're going to really drill down into one particular requirement that is the focal point in this new case that we're going to be talking about. So first of all, just to make sure all of us understand what a continuity billing plan is, in very simple terms, it's what you typically see in a membership website where the customers or members are billed periodically, typically on a monthly basis, until they opt out. There's no guaranteed time or term for the agreement or the membership. It's just, we're going to bill you $49 a month until you decide you want to opt out. That's what a continuity billing plan is. It's also known as a negative option plan. So that's generally what we're talking about. Now, how are continuity plans regulated? They're regulated by the federal statute known as the Restore Online Shoppers Confidence Act. We call it ROSCA by acronym. There's also a similar statute in California, but we're going to talk about just ROSCA tonight. And we're going to focus on the elements that are in red on this slide. And we're talking really about the disclosure. And that's required, and those three elements are that there needs to be a clear and conspicuous disclosure of the billing plan and all of the recurring charges, which are considered to be material terms. Now, there are other parts of ROSCA as well that you see in the bottom three black bullets. There's supposed to be informed consent, express informed consent, and easy opt-out so they can get out. And oh, by the way, if you don't comply, there's a civil penalty of up to $16,000, and it's not just $16,000 total. It is $16,000 per violation, which can really add up depending on the number of members that you have. So let's focus now on the disclosure requirement. And you see the ROSCA statute speaks in terms of a clear and conspicuous disclosure. That's all the statute says. They don't go into any detail about what it means, and the statute expressly provides that the Federal Trade Commission has the responsibility of enforcing this statute on behalf of consumers, right? So then the FTC's interpretation of what Congress meant when it said clear and conspicuous is really what is at issue here. And as we'll see in this One Technologies case, the FTC has interpreted clear and conspicuous to mean unavoidable, which seems to take everything to a higher level than clear and conspicuous. And I'll explain that in detail in just a minute. And again, the FTC has no concise explanation, and we have to rely on cases that interpret this rule, the unavoidable rule, in relation to specific facts. And that's how we start getting a clear picture of what the law is with a new law, such as this. So
Hey,
we do know.
Can you, Chip?
Yes?
Yeah. Can you slow down just a little bit because you're breaking up? There's like
Okay.
people are saying they're having trouble hearing you and stuff. So and I know I'm hearing you break up a lot. So maybe you just slow down a little bit, then you might be able to maybe it will just help with the technology getting the voice out. Okay.
Well, I'm an old son boy. I can talk slowly if you want me to. I'm pretty good at it. All right. So right now, or up until the One Technologies case, we have, through case law, developed a pretty good idea of what unavoidable does not mean, right? First of all, it doesn't mean that you can bury terms, on a linked terms and conditions page. It doesn't mean that placing terms at the bottom of a checkout page where they're hard to read and find is going to work. And it doesn't mean placing them below the fold and away from the order button. That's all been decided, and we know that those are clear violations of the unavoidable requirement, right? So we really want to look at what really works here and get a little bit more definition and understanding of what unavoidable means, and that's what happened in this case involving One Technologies. And the simple summary of the case is that One Technologies is, of course, a membership website. One interesting aspect of the case was that not only was the FTC involved as a plaintiff, but so were the states of Illinois and Ohio with respect to their little FTC acts. You remember 28 states have very similar statutes to the federal FTC Act. The rest of the states have consumer protection laws, but 28 have almost a mirror image of the FTC Act. So they joined in as well with the FTC in the lawsuit. And the defendant's marketing strategy was to offer free credit scores to consumers. You've seen those ads on TV probably. But then there was an automatic upsell to a continuity plan or a membership for which there was a continuity billing aspect, and the membership had something to do with credit monitoring. And that's where One Technologies got into trouble. Now, we look here and we can see that One Technologies didn't just not have disclosures. They had a fair number of disclosures about the continuity billing plan. And you can see here a summary of those. On their home page, there was a notice at the top. On an inside page, they had a link to an offer details box that could be clicked where the consumer could read the continuity billing terms. And then on the sign-up page, there was another offer details box beside the credit card fields and above the order button. So One Technologies apparently was represented by an attorney. They didn't just dream this up. They felt that they were in compliance with these disclosures. Unfortunately, it didn't wash with the Federal Trade Commission. As a result of the consent order, and by the way, there's a copy of the consent order in PDF format in the members area if you're interested in putting yourself to sleep one night, can't go to bed, just go to that one and read it and you'll fall asleep. It's so boring. But they were permanently banned in the future for violating ROSCA. They were nailed for only $22 million, and they're saddled with very significant compliance reporting requirements for 20 years. So they've been hit pretty hard. So let's get back to this unavoidable definition. And this is language on this slide that was taken from the consent order. This is the FTC's definition of what unavoidable means. But we really don't have a clear picture unless we see how it's actually applied to specific facts. But here is the definition. The disclosure needs to stand out in the context of the presentation, which is typically an order form, right? and it needs to be sufficiently prominent. And look at the blue highlighted text in terms of size, shade, contrast to background, time on screen, and location. So prominent in connection with those areas, such that an ordinary consumer can notice it, read it, and comprehend it. That's what is meant by unavoidable according to the FTC. And the big takeaway here was that despite the fact that there were these multiple above-the-fold notices, they were not sufficient, causing One Technologies to be out of compliance simply because they weren't big enough, they weren't bright enough, or prominently positioned enough. Now, you see here 3 enoughs. And again, how much is enough? And that still left a little bit to the imagination. But I'll give you, I think, what I think this really means when we get to the concluding slide in just a minute. Now, this is an interesting, the next 2 slides are very interesting because they were taken from my prior website, digicontracts.com, right? And I provided the disclosures, obviously prior to the One Technologies case, and I provided these disclosures in a way that I believed was clearly in compliance, right? I mean, that's what I do. But since I read the One Technologies case, I have my serious doubts as to whether the disclosures that I had were really compliant. Now, if you look at the red arrow points to a disclosure at the top of my order form. That's a clip taken from the top half of my order form, right? And if you look at the red arrow, it's pointing to yellow highlighted text, which is the disclosure of the continuity billing plan element. It reads, after the first year, $10 per month until you cancel. So I'm thinking that may not be big enough or bright enough or prominent enough, right, according to the rule for being unavoidable. So now I'm thinking that you might ought to look at the blue arrow. And I've taken in the blue arrow the text at the bottom and moved it up to the top so it's more prominent. It's a different color so that it jumps out. And the size of the text is not quite as large as the headline, but it's larger than the text at the bottom of the slide. And it reads again, after first year, $10 per month until you cancel. I'm almost positive that would be in compliance. And I'm very doubtful that my first attempt prior to this case would have been in compliance. So I would have probably been nailed for a violation myself, even though I thought I was being pretty clever about this. Now, here's another part of the registration process, again, taken from my website. And if you look at the red arrows, you see the arrow pointing to the right is pointing to a link to go pull out your credit card. Well, you've already got your credit card up there, but it's to actually process the order. And then at the very top left, you see in yellow highlighted text, in small text, but it's still highlighted, the billing and cancellation terms. And then at the bottom, at the top of a scroll box of my membership agreement, you see these bullets at the very top. In fact, it's above the title of the agreement. You see at the bottom of the slide, membership and content license agreement. This summary was at the very top. After the first year, we charge your account monthly at $10 a month. So the red arrows point to what I had there, and I think it's probably pretty good. But now, since the One Technologies case, I might try to increase the size of the text in the upper left corner where the blue arrow is pointing. I might try to change the size, maybe the color, and possibly for the text at the top of the membership and content license agreement. The problem here is that I used UltraCart as a shopping cart, and I don't have a lot of flexibility to change the format that UltraCart has adopted for its shopping cart. I mean, they give you a little bit of flexibility, but not a lot. So there are some limitations here. But I think that the blue arrows would indicate some changes I would make, in order to be compliant now with what we've learned from the One Technologies case. So what might we conclude here as we finish up about One Technologies? First of all, it's not sufficient just to place it above the fold, and it's not sufficient just to sprinkle around several notices the way One Technologies did. Of course, we know now that it needs to be, quote, unavoidable, and those four elements, size, font, contrasting color, and location, are critical. But here's where I think this is where One Technologies really fell down. We go back to the beginning, and what I said a few minutes ago was that they were clearly represented by attorneys who had read the cases, just as I had read them before the One Technologies case. They sprinkled in various places above the fold the notices which they, I'm sure, believed were sufficient and in compliance. But here's the problem. They believed that the notices were sufficient to provide information to consumers who would then, be able to make a buy decision based on the full disclosure. But what happened was a lot of the consumers didn't read this stuff. They're in a hurry. They see free credit report, and they're sort of blinded by the word free. They don't read anything else around it, even though it's not in fine print, not below the fold, and they click, yeah, sign me up. It's free. I want to do it. And so a lot of people were finding out later that they were in a continuity billing plan. I believe it was $49.95 a month. They were billed for the credit monitoring service, for the membership service, and they started complaining. That is where One Technologies fell down, because if you put the notices up there and you're starting to get a lot of complaints from people who say they didn't know they were in the plan and they want out immediately and they're raising Cain about it, you know that it wasn't unavoidable. I mean, even though they should have read this stuff, they didn't, and they're starting to file complaints. And that is exactly when One Technology should have revised their notices so that the complaints would have stopped. And I think that's what the Federal Trade Commission is saying when it's unavoidable. You can actually put the disclosures on the website and then test them. Do you get complaints? Do you get people who claiming that they didn't know they were in the program? And if they do, then I think that's very clear and convincing evidence that we're not unavoidable here. So that's the big takeaway. And the ultimate test of whether you've really satisfied the unavoidable requirement is the actual results. That's the last bullet on the slide. And if you see actual results indicating confusion, you'd better start amping up your disclosure, or you may find yourself in the sad position that One Technologies found itself in. So I think that's the ultimate lesson from the case. And I would like to point out one thing in conclusion, and then if we have a question or two, maybe Alan can feed me a couple of questions, and then he's got some very important information about the affiliate program. And that is this. I have this past weekend updated the members area for this information about the One Technologies case. You'll see a series of videos in the section titled Marketing Agreements, and the last video in the series is talking about what we've talked about tonight. I've updated that video to cover this new development. I've also updated the cheat sheet that deals with this type of notice. And then I went to the additional step of putting a link to the consent order for One Technologies that is on the FTC website. But the point I want to make is you wouldn't know that there has been a change. There's not really a change in the law. There's just a new interpretation of the same law, right? But it is a new interpretation that is significant for anyone who either has a membership site or is planning one, right? So you wouldn't know about those additions and updates unless you were reading Alan Cutt's emails that he sends out twice a month about these Hangouts. Now, you might get the email and you might say, well, I've got plans, I'm going out to dinner on Tuesday night, but at least when you get the email, you know that there is an important development that recently happened affecting membership sites. So then you can go look for the update or look for the replay video. But you know that it happened, you can make a note of it and then pursue the information later if you're not able to attend the Hangout. So my point ultimately is this: don't blacklist these emails that are coming out that Alan sends out about the Hangouts, because we choose those topics very carefully. We believe that there's something very significant that you need to know, and in most cases, the significance is it's something new that's happened very recently that you really do need to be aware of, right? So, look at these things, be aware of them, and then know that there's new developments that might be affecting you. So we've discovered, I think, that these Hangouts really have more value than I think we originally contemplated when we started them. So that's an important point to make. And now I'm going to go back, after I've finished my comments, I'm going to go back to my screen. Do we have any questions that I might answer, or Alan, has my explanation been so good that there are no questions? Everybody understands it. I'm just kidding. I'm kidding.
I have to say, and I'm just going to say what everybody else is thinking. So it's nothing about you or against you or anything else. This has got to be one of our worst technology hangouts ever, because you were breaking up so much during it that I'm hoping that Google Hangout records it better, and maybe they do since they're in the back end. Maybe it's recorded better, but everybody, you were breaking up so much during the Hangout, it was really hard to hear you, and some of it's bandwidth, some of it's whatever. I told you the other night I was on a Hangout with Mike Filsain and Andy Jenkins, and theirs was bad. I don't know if it was their internet provider or if it was just Google in general. But we apologize, guys. It is what it is. We have to go with what we have, and
yeah, I mean, I've got the fastest connection that Comcast makes, or provides. So I don't know. I've just reduced the bandwidth requirement one step again. Now it's down to 50%. So maybe that was part of it. I don't know, but
yeah, I don't know. Well, we'll see what we can do.
Are there a couple of questions that might be important?
Let me see. Does anyone else have trouble with these webinars? At 8 minutes before the webinar, the clock countdown. No, they didn't get logged in time. They just didn't log in. I heard everything. Thank you. No real questions. Yeah.
Well, that's good. I take that as a compliment, despite the fact that.
Wait a minute. We got somebody saying at the I got a feeling she's typing something else, because she says at the conclusion screen, and then she hit enter or whatever. Okay. Here's the one you need. Fran Torsen. The connection was great. I'm sufficiently scared to death about membership sites.
Well, let me mention one other thing. If the transmission was bad on this one, all you have to do is go to the membership area, log in, go to Rules of the Road. The heading would be Marketing Agreements, and then scroll down to the last video in the list, and it's pretty much a replay of what we have here. And I know that there's no garble, because I did it this weekend and everything worked out fine. So there's a clean video there if you want to go and sort of get a rehash of what we talked about tonight.
Okay. Here we have a question from Susan. Are you there? Can you hear me?
I can hear you.
Okay, you're breaking up again. Okay, we have a question from Susan. It says, so what's the recommendation to be clear on this? It moved. To be clear on this, if you say a coach or a small business like that and you want to offer a monthly plan. So basically, what's the recommendation for
Well,
a coach or a membership plan?
I mean, the best recommendation is to either go and watch the replay of this Hangout video or go to the members area, as I just mentioned, and watch that one, because in both of these videos, you see the last two slides, or the example slides, right? I would look very carefully at those example slides. I would try to follow something close to the blue arrows. I mean, the before is the red arrow. That's what I did before the case. And then the blue arrow indicates what I might amp up to be in compliant with this case. So look at the before, look at the after, and then try to follow that as a lead. And then be very careful to be attuned to any complaints you might get from members who say, you know, I just discovered you've been billing me $30 a month for the last 5 months, and I didn't sign up for this. Give them a very prompt refund. And if you're getting some of those things, then amp up the color and the size and just keep doing it until you don't get complaints anymore. I think it's that simple.
Yeah, we have a question about Joseph, and I think an example of this is our registration page. It says with what you thought was complete compliance, would you add? Somebody else just pushed it in. If it moves, I got to move it back. Move it back. Okay. With what you thought was complete compliance, would you add a page requiring someone to click a payment page? And I think that we kind of do that with when anytime anyone purchases FTC Guardian, before they can even check out, they have to tick a box that is not self-ticked. They have to tick the box, and they have to enter an email address and click I agree before they can become a member. And at the moment, we're only a one-time pay, but the same would be held true when we are an annual pay coming next month. So we are making sure that they agree before they even take the next step. So, Chip, you want to add anything to that?
I mean, we're now talking about the relationship between an order form, which is usually the place where a customer clicks to get into the registration process. And the last step of the registration process is you submit the payment authorization, right? So once you get in that registration process, you have to select what you're going to buy. And if it's only one option, there it is. But there might be a couple of 3 different options, or different levels of membership. So you select one, and then you get to that page that you see on the interior, the second of the 2 example slides. The first one was the order form phase, right? So at the order form, you need to have a disclosure that you're going to get billed X dollars per month until you cancel, right? That's that step. And then once you get inside the registration thing, then I think you need to have a membership agreement, right? A membership agreement. And at the very top of that agreement, you would have the bullets that you see on my example that just list the various points about billing. And then you go to the final phase where you enter your credit card information or PayPal or whatever and hit submit to pay. So I think it's that middle step. If you look at those examples on the screen, on the slides, I think you'll be in good shape.
Yeah, we have another question from Pamela. It says, it sounds like the responsibility for communication on the website is on us, which is true.
Absolutely.
Not on the consumer. Is this true across the board? And then this is what we discussed.
And I think the answer is overwhelmingly yes.
Let me finish.
Okay.
Because she wasn't done yet, and this is what we just discussed before. This seems true with testimonials as well.
Am I free to speak?
Free to answer it, but talk about the testimonial stuff that we just talked about before.
You want me to mention that?
Yep, I want. Yeah, she asked the question, and she needs to know.
Yeah, if there's one thread that goes through almost every one, if not every one of the FTC regulations, and understand that the FTC is here to protect consumers. The idea is consumers are really powerless to protect themselves in this, world of commerce, and they need a government agency to have enormous powers, by the way, which the FTC has, to represent them and to enforce their rights. Correct. So that's what the FTC is. It is the ultimate consumer protection governmental agency. That's what they do. And the common thread that runs through every one of the regulations I'm involved in is basically disclosing certain terms and conditions, such as the continuity payment thing. And it's particularly critical when you lure someone into a continuity plan with a free offer. I mean, that really gets the attention of the FTC, because they know the consumer's eyes are getting big at the word free. I'm going to get a free credit report here. That's great. And they don't take the time to read the surrounding text about oh, by the way, after the first month, we're going to ding your credit card for almost $50, right? So when you lure somebody with a free offer, they really pay close attention. But whether there's a free offer or not, the idea is that it's the seller's responsibility to disclose material facts. And a material fact is anything that a consumer, and by the way, we're all consumers, right? I mean, we're sellers, but we're also wearing our consumer hats as well, right? And so the consumer needs to know what the material facts are that are involved or important to a buy decision, right? And if you omit, if you misrepresent something, right, or if you omit critical information, like, you buy this widget, but in order for the widget to actually work, you need to buy a service contract too, but they don't disclose that. Well, that's material. If you're a consumer, you want to know what the total cost of ownership is if you buy something, right? So you buy this, and then you get surprised with a charge later, you're upset. So the whole idea is to provide all of the information that a consumer needs to know to make a reasonable, meaningful decision to buy. And it's our responsibility as sellers to do it. And so when you talk about testimonials, the idea is that the consumer needs to know that the testimonial was, I hate to use the word legitimate, but I will, for lack of a better term, and not influenced by something else that we don't know about, such as an affiliate commission payment or a freebie, or maybe there have been an employee at one time of the company and they've got a relationship with you, and the consumer might want to know that because it might have affected the objectivity of the testimonial. So in 2009, in December, the FTC came out with these rules that say if you post testimonials on your website, you need to disclose if you have a material relationship with this affiliate, in many cases, and so you have to say, this person is an affiliate and will be paid a commission on sales. It doesn't have to be anything more elaborate than that. But if you're a consumer and you see this glowing testimonial, but then you see, that they're an affiliate and might be paid a commission, you might think, well, okay, they may be honest, they may sort of be objective, but it's important to know that they could be influenced by the fact they're going to be paid if a sale is made. So, I mean, we as consumers, we need to know that information. So it's always full disclosure of relationships and everything that would be material to a buy. And it would be material to know whether someone is influenced by something else other than their love of your product or service, right? So, I mean, that's the common thread through the whole thing, full disclosure. Now, obviously, as we go through these hangouts and we explain how the FTC interprets the rules and all, there are different permutations as to how all this works, but if you boil it all down, it's pretty much full disclosure to a consumer so that they can make an intelligent, informed decision. That's pretty much the gist of it. I'll get off my soapbox. Any other questions? And then I'm going to turn it over to Alan for some affiliate information. I can't hear you, Alan.
I have that. Can you hear me now?
Yeah, you had muted yourself.
Yeah, I muted myself. I just want to drive that home a little bit and say that we had to do the same thing. We had a testimonial from Fran, who is a very a very good supporter of FTC Guardian, and we're having to go back
And
to
by
her
the way,
testimony.
we appreciate the testimonial, Fran. It was excellent.
Absolutely, we totally appreciate the
It was
testimonial.
terrific.
Totally appreciate the testimonial, but we published the testimonial, and after Chip reviewing the testimonial, and again, this is what happens when you have an attorney who's active in internet law day in and day out. This is what he does for a living. Look at your business and what you're doing. Is Chip looked at it and said, we've got to disclose that she's an affiliate. I mean, because she's given us testimony, we have to tell people that she is an affiliate and she's paid a commission if she does it. So we're posting the testimonial because obviously it's there, but we also are noting as of tomorrow, because my programmer's putting it in there tomorrow, that she is an affiliate and has paid a commission if she makes a sale. So, not that it's a bad thing. It's just you just need to be honest, and you need to tell people if there is, payment going on. It's what you need to do. So, we're doing it ourselves. Let me see.
By the way, I've turned the screen over to you, Alan.
Oh, are you okay? 'Cause I'm looking at. Haven't been able to get on live Hangout, blah blah blah, in a long time. Okay, I think we're okay with questions. We're pretty good. If you still have questions, just email them to support at ftcguardian.com, and we'll see if we can follow up with them. I mean, we're already running on 38 minutes here, so we want to move on as quickly as possible. If I just want to tell everybody about the affiliate program, and number one, just go to let me post it in here. I'll post it in the let me just post it to the website real quick. Affiliate. Oop, that's not it. I think, guys, I'm just trying to get the affiliate link if you're not already an affiliate. So I think everybody should see that. Let me see. Affiliate. Okay, display affiliate link. There we go. There's an affiliate link display in there. Just so you know, our conversion rates on our webinars are very good. And if you'd like to sign up for to be an affiliate and promote our webinars, we would very much appreciate it. We have the new product that we call Ftc Auditor Pro, which we really think, and we haven't started promoting it yet, and we will start promoting it when we get back from the cruise because we'll have some time. I'm not going to start any advertising or promotion this week because we're going to be on the cruise for a week, and I don't want to do anything that I can't follow up on and can't take care of while I'm out for 10 days. So I will start it the 1st of February, and I will be promoting on Facebook, Google, Bing, solo ads, everything, promoting Ftc Auditor Pro. And it's an excellent opportunity for you. It's a low entry point to get people into Ftc Guardian, where they can do the Auditor Pro, and they actually are able to answer questions. They use, what's the technology called? It is RB,
Rule-based document assembly. I call it RBDA.
RBDA. So it's rule-based document assembly. And basically what we've done is reversed the questioning in answering system so that they're asked questions and given answers to their questions in a way that shows them where they need to be making sure that they're compliant online. And then Chip has put together a series of 10 or 15 videos in each section that they answer the questions, and they get a video telling them why they need to be a member of FTC Guardian and what they need to do and blah, 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 and all that stuff. So it's an exit program. It's only $7. So it's an exit program to promote. It pays 100% commission, which is excellent for you guys. So you get 100% commission on that, and then if we get them closed in the next 30 to 45 days or whatever it is, then you get a 50% commission on the sale. And the whole objective is to get them on our webinars, because we know our webinars close. And I was in a meeting the other day with Michael Sane and a couple of guys, and I was giving them our numbers. People that are on our list close. On our list, they're closing at $19.73 per lead. So that means if they're on our list, if they opt into the webinar, they're closing at $19.73 a lead. Our affiliates are closing at like $12.43 per lead, something like that, because it's a different list, so it makes a little bit of a difference. But that's what people opt into the webinar, and that's what the whole idea is. If you can get them into one of our webinars, and that's all you got to do is get them into FTC Guardian, or excuse me, into FTC Auditor Pro, or into one of our webinars, and it's a pretty high conversion rate once they get into our webinars and FTC Guard and FTC Auditor Pro. So anyway, that's about it. If you have any questions, send us an email, support at ftcguardian.com, and let us know. Let me look here at questions, because it says I haven't been able to get on a live hangout for a long time. Finally now, blah, blah, blah. Great, thanks. Okay, that's really the last one. All right, that's all we have. Guys, we're going to be out. We leave, both of us leave on Saturday for the cruise, for the Marketers Cruise, and we'll be out of town for, I know I'm out of town for 10 days. I don't get back till February 2nd or 3rd. So Chip and I will be meeting on the cruise, scheduling out the year, and we look forward to helping you and to helping any of the prospective clients or customers that you might bring on board. So that's all I have. Chip?
Okay, I've taken back over the screen. I think that's all we have for tonight. We don't need to belabor this anymore. We do appreciate your attendance, and for goodness sakes, keep reading those emails that Alan's sending out about the topics, and that's the best way to stay on top of current developments, regardless of whether you attend, because there's always a video. So good night, everyone. Have a great day tomorrow. A very successful year ahead, and we'll be back to you early next month for a couple of new hangouts. Good evening, everyone.